Good afternoon. Welcome to today's event. Thank you for being with us. My name is Stephen Schaefer, and I'm the director of the Federalist Society's Regulatory Transparency Project. In order to get right to this discussion and debate, I will keep my introductions of our experts brief. We welcome you to learn more about our accomplished panelists at fedsoc.org. That's fedsoc.org. First, we have Jonathan Berry, who is a managing partner at Boyd & Gray & Associates. Jonathan provides strategic counsel and litigates on issues at the intersection of law, politics, and public policy. He helps his clients navigate the emerging field of bureaucratic overlap in government, corporate America, and capital markets, especially in matters relating to environmental, social, and governance factors. Prior to his current position, he served in government. He headed the regulatory office at the U.S. Department of Labor, where he oversaw the development of dozens of proposed final rules. Second, we're happy to have with us Akiva Shapiro, who's partner at Gibson, Dunn & Crutcher. Akiva is a litigation partner in the New York office. He's the chair of the firm's New York Administrative Law and Regulatory Practice Group, co-chair of its Religious Liberty Working Group, and a member of the firm's Appellate and Constitutional Law, Media, Entertainment, and Technology practice, as well as the Securities Litigation Practices Group, among others. Mr. Shapiro's practice focuses on a broad range of high-stakes constitutional, administrative, commercial, and appellate litigation matters, including bringing suit in Wong versus NYCERS in the Supreme Court of New York. We're also happy to have with us Vincent Fernuccio, who is president of the Institute for the American Worker and senior fellow at the Mackinac Center for Public Policy. As president and co-founder of the Institute for the American Worker, Fernuccio brings over 15 years of expertise in labor law and policy. He holds advisory positions with several organizations, including senior fellow with the Mackinac Center. He served on the U.S. Department of Labor transition team for the Trump administration and as a member of the Federal Service Impasses panel. He also worked under George W. Bush in the Department of Labor. Moderating today's panel is the Honorable Paul Atkins. Paul is chief executive and founder of Potomac Global Partners, LLC, a financial services consultancy that provides industry and regulatory expertise. At Potomac, Mr. Atkins leads clients' work for financial services firms regarding an array of issues, including regulatory requirements, investigating and improving the effectiveness of compliance systems, and designing and implementing compliance policies and procedures. Prior to founding Potomac, from July 2002 to August 2008, Mr. Atkins served as commissioner of the U.S. Securities and Exchange Commission. During his 2 terms, he advocated for better transparency and consistency in the SEC's decision-making and enforcement activities, along with smarter regulations that consider costs and benefits. If you could please welcome our panelists to the dais. Thank you.
All right. Well, looks like we have a good turnout today, so thank you all very much for coming, and a lot to talk about here on a very interesting and timely topic, I think. So first, I don't think anyone has to, except maybe you, Akiva, has to give any kind of disclaimers, but anyway, active litigation other than that. But so we're here obviously to talk about Wong versus NYCERS and the ESG action at the state and local level. And so this is quite a interesting case and pretty one of the first of its kind. So and so if you all haven't read the pleadings in the matter, I really commend them to your reading. They're pretty interesting. But basically, Wayne Wong is a union member and a former New York City municipal worker, and so they've sued 3 New York City pension funds over the fund's decision to divest $4 billion in fossil fuel securities. So the plaintiff's lawsuit tests the limits of the existing law and discusses fiduciary duty and those sorts of things, which is pretty clearly laid out in New York law. So there are lots of pivotal questions on responsibilities of pension funds and their duties and their capacity to act on broader issues that may fall more in the political side of things than actually in pension administration. So huge implications of this lawsuit for probably other states as well. And so we'll get into all of that. And but the essential thing is under traditional common law and ERISA types of constructs, the fiduciary duty of the fiduciary is to maximize returns. So the question is how to do that and how to get into it. So anyway, so I think at the beginning here we should uh, go into the basics of the case for especially if people haven't really seen about it. So Akiva, since you're the man on the spot, with a pen and up there at the podium with the judges, we'll let you go.
Sure. Thank you for that introduction. Thanks everyone for coming today. Thank you, welcoming me to DC. I just came in from New York this morning, where I'm based. And I do want to give a couple disclaimers. One, as Paul mentioned, it is active litigation, so I'm going to try to answer questions and sort of provide some insight to the best I can, because otherwise, what's the point of being here? You could just read our complaint, but there may be some limits to that. And the second is that I am not an expert in labor law or pension funds. We do have experts here on that, and obviously I know something of the issue from our case and some other cases, but I'm really a litigator first. And I litigate against New York City, against New York State in a lot of different actions, a lot of different range of cases. I did the case for the Diocese of New York that we won at the Supreme Court, opening up houses of worship during COVID, the case challenging New York's COVID eviction moratorium, and a bunch of other cases against New York. So that's really where my expertise is. So I may turn it over to these folks on the panel if there are technical or detailed questions, even if it relates to something in our lawsuit that still may be beyond my depth of knowledge at the moment. I also want to acknowledge Gene Scalia, who is my partner on this matter, and is actually argued at the Supreme Court this morning. So I don't know if I'm filling in for him exactly, but he certainly was not available to attend. And also Blake Lanning, who's here, who is working with us at Gibson Dunn on the case. And we've got another couple associates as well on the case. So just very briefly, the players first. I like to sort of set the scene. So we've brought this lawsuit against 3 of the major New York City pension funds: the Teachers Retirement System of New York, the Board of Education Retirement System of the City of New York, and then New York City Employees Retirement System. And the technical distinctions between those maybe don't matter too much, but one basically represents teachers, the other one represents employees in the New York City education system who are not teachers, so an administrator, somebody who provides social services, but within the education system. And the third is a broader general New York City pension fund for New York City employees. And I think the important thing is that each of them have a board, and each of those boards are comprised largely of either, I don't call them political appointees, but appointees who have a connection to either a mayor's appointee, or on the board are heads of the boroughs, the borough heads for each of the 5 boroughs of New York, appointees, comptroller. So even though they act and are supposed to act as we lay out, and all the lawsuit is about, for the benefit of the beneficiaries, there's a political tinge to the composition of the boards, and that's central to our lawsuit in that we're using and are using the retirement funds not for the benefit of the New York City employees who've paid in and are relying on them for their retirement funds, but instead for political purposes to advance a climate change agenda, which whether you think a climate change agenda is a good thing or a bad thing, it's not proper to use billions of dollars of hard-earned retirement funds from New York City teachers and subway operators and other line workers for political purposes and to advance the political agenda instead of to advance their economic pecuniary good. So those are the defendants in the case. Plaintiffs in the case, and I won't go through all of them, but the lead plaintiff Wayne Wong, as Paul mentioned, was a New York City subway operator. And just a little insight into these kinds of cases, as you may or may not know, picking your plaintiffs is very important. Finding the right plaintiffs is very important in a lawsuit like this. And so, we're very happy with our plaintiffs because we were able to find individuals who truly are representative of the New York City workers. Mr. Wong worked throughout the pandemic as a subway operator, putting his life at risk, so that people could get to their jobs and continue life. And our other employees are also teachers and other individuals who work in the New York City schools. So it's real, true-blooded, everyday New Yorkers who are not deep-pocketed. They worked for decades to put money into these funds, and they entrusted the boards of these funds, the trustees, to invest for their benefit. So very briefly, the background on the case itself, and I don't want to take too much time on it because I want us to be able to have our discussion. But basically in 2021, and this is a long time coming, but the boards, the trustees of these three pension funds decided to divest, blanket divestment, full divestment from fossil fuel connected stocks and securities. So they said, in order to advance their climate change agenda, we're going to pull all money from these three pension funds. These three pension funds, by the way, manage about somewhere in the range of $150 billion of retirement funds. And they committed to and eventually pulled out about $4 billion, divested $4 billion of holdings that they had previously had that the previous fiduciaries had thought were good investments, and not because of any investment rationale, but because they wanted to advance this agenda. Pulled the full $1 billion out, full stop. Other things they did as well, which kind of go into the mix. They also prioritize investing in green investments and some other things. And so we brought this lawsuit, first of its kind, as far as we know, and we alleged that this is a breach of fiduciary duty under New York common law and also under New York regulatory law, which imposes similar or essentially the same fiduciary duties on the trustees of these pension funds. That it was a breach of the duty of loyalty. They have an undivided loyalty to the beneficiaries to maximize returns. And number two, a violation of the duty of care, that they have a duty to essentially make their investment decisions through a transparent and appropriate process, and that this was all done, the discussions, the analysis, if it existed, was all behind closed doors, and that so there was no transparency. As far as we can tell, there was no appropriate process, appropriate weighing of costs and benefits, of risks and rewards. And so that's what the lawsuit is. So we brought the lawsuit relying on these age-old common law, fiduciary duty, trust law principles in New York law, and the defendants have filed a motion to dismiss. We've opposed that. Reply is coming, and we expect there'll be an argument on the motion to dismiss in the coming months, and so that's the basic story.
Well, before I let you, before we move on, I just wanted to kind of clear up a couple of things. Maybe we can talk about that. These are government pension funds and run a little bit differently than New York has various pension funds. So there's the New York State Controller, who has a common employee retirement fund, but he's the sole fiduciary of that one. We're talking about now other city funds in particular. So maybe you can just touch on what standard are we talking about? Because does ERISA apply? Is this only
Sure.
common law? Is this a New York special statute? Maybe you can go into that.
Sure. So yeah, ERISA does not apply, and that's important because the primary argument that the funds have made in moving to dismiss the case is a standing argument under the U.S. Supreme Court's decision in Thole, which held 5-4 vote that in order to have standing to bring a claim under ERISA, you had to show fiduciary loss or significant fiduciary risk to pecuniary risk, and that the mere violation of a fiduciary duty, a duty of loyalty or care, was not in and of itself enough to establish standing. So these funds are not governed by ERISA. They're governed by New York common law as well as by New York certain New York regulations, regulatory law, which have their own private rights of action. And so we've argued that Thole's an opposite, and that under longstanding New York law, there's a variety of bases for standing, and we could talk about it. But fundamentally, under New York common law and New York standing law, the violation of the duty of loyalty in and of itself establishes standing for a plaintiff. And so it takes you out of the whole world of needing to show pecuniary harms or a significant risk of pecuniary harms, although we do allege that as well.
Right. All right, and so that's an important distinction, I think. And then second, as far as the plaintiffs go, so it's very interesting to get 4 individuals who are brave enough to come forward. So that was very good. But there's also an organization as well,
Yep.
Americans for Fair Treatment, and maybe you could talk a little bit about that and how they play a role here.
Sure. So their primary I guess mission, well, I guess, so I'm just thinking about how to come at it. So one of their primary missions is to protect union workers from abuses by government authorities, and so especially government authorities who are running their pension plans, and so from we think that it's a helpful plaintiff to have because it illustrates the broader ramifications and broader impacts of this lawsuit. Yes, we have 4 individual plaintiffs, but there are actually hundreds of thousands of New Yorkers, New York municipal employees who are being affected by this. And so the Americans for Fair Treatment is representative of their interests as well as the interests of workers and municipal employees more broadly across the country and the potential impacts there. From a standing perspective in New York has a pretty liberal and broad view of standing, and I think it's another thing important to note. We're in New York State Court. Article 3 does not apply. So the things that you all may think about if you're litigators about what you need to show Article 3 standing, it doesn't apply in New York. The states can create their own more liberal standing requirements, and New York has a fairly liberal standing regime, including for organizations, where basically you have to show that you're within the zone of interest that's being protected by a statute or a right, and that you can show some individualized impact by it. And there is an injury in fact aspect to it, but it is also given more liberal treatment than in federal court. And so Americans for Fair Treatment, they're in our view, and we argue in the papers, has standing here because they're representing individuals who are affected by this law. And again, it's important for us to show and really illustrate that this is broader ramifications than just our 4 individuals.
Good. Well, so what I want to do, I think, first is maybe we can talk about how this is kind of a first of its kind case. So I might turn it to Vinny, and then I wanted to get back to some of these issues of standing and just disability, and rather than put you on the spot, but you can chime in. Obviously, maybe John, you can chime in. So Vinny, maybe we can go to you and talk about the ramifications, potential ramifications of this suit, and what that may portend in the future.
Absolutely, and thank you, for Federalist Society for hosting me and hosting this event. Akiva, I was going through the motion to dismiss, and I want to give a couple quotes. Sorry, they're bracing themselves. Say, waste of time, swiftly end the drain on resources, radical, observed, no motion. Man, you touched a nerve.
We did.
Awesome. I think that illustrates, the gravity of this case, the unpreparedness of the New York City comptroller and the pension funds. They basically thought no one was going to call them on it. And the complaint and the response I thought were beautifully written, and you make a lot of really good points. But before we get back to the case, I want to give a little bit of history. I mean, I've been doing ESG since before it was cool. It was in the bush.
It's still not cool.
It's still, since it was uncool. Excuse me, John. Going back to the Bush administration, helped draft 2 interpretive bulletins, wrote memos to draft 2 interpretive bulletins, and that was response to Robert Reich and the former Secretary of Labor under President Clinton, saying that we want to be doing well by doing good. Back then it was called ETI, or Economic Targeting Investing. Then it got shifted to SRI, Social Responsible Investing. Now it's ETI. For the moment, Larry Fink is trying to Kaiser Solseize ETI. If you haven't seen Usual Suspects, he's basically saying that the greatest trick the devil pulled is convincing the world he didn't exist. And that's essentially where ESG is going. So a little bit of fair warning. At least from the left, you will be hearing less and less about ESG. They're still going to be doing it, but they're just not calling it ESG. And you're already seeing groups like BlackRock disbanding their ESG portfolios and funds, but they're going to probably be doing it in other ways. So just a fair warning of where things may be going. As far as the New York City pension funds, and I'll use that as kind of an et-al term for a lot of these actors, what we're seeing with them and what we're seeing across the board is a lot of focus on environmental issues. And I kind of want to step back away from environmental issues. I'm a labor nerd at heart, and I've been following this from a union angle. And same group of characters with the New York City pension funds. They're doing several proposals that are trying to advance union interest at the expense of workers. For instance, they actually got Apple this January to settle, and a shareholder resolution was pressuring Apple into talking about and doing an audit of how they work with unions and their collective bargaining practices. The New York City comptroller, Brad Lander, said that was an example of ESG done right. This is, before they got the memo, we're not supposed to call it ESG anymore. Let's put that aside. The chair of the teachers' retirement system said it makes it easier for workers to organize. Well, what business does a pension fund that, and I know we're not talking about ERISA here, but common law, that is supposed to be solely focused on the participants and beneficiaries and the retirement security, why do they care about making it easier for workers to organize? And it wasn't just Apple. These type of proposals were at Starbucks. It actually passed in Starbucks in March. There were measures at Amazon, Walmart, CVS. There's other measures. They call it non-interference. And let me tell you what non-interference means. It means that there's shareholder resolutions brought by these public sector pensions to try to bully corporations into taking away the secret ballot from workers and not telling them what would happen if a union comes in to organize them. They're called neutrality agreements. And these proposals have been introduced at Delta, Chipotle, DoorDash, Tesla. I know we're going to probably talk about DEI, another one that these pension funds and frankly other union pension funds are pushing because, hey, if you can give a bruise on DEI, then we can use that to go against these companies, have these type of anti-PR campaigns called corporate campaigns, including these shareholder resolutions to get these companies to agree to taking away the secret ballot from workers, not talking to them, giving away worker personal information. And all of this is under what we're still calling, the left is moving away from, these ESG proposals and shareholder activism. So while there's a lot of talk, the lawsuit is on environmental issues, and across the country, that's where a lot of focus has been. On the E with ESG, don't forget the S, don't forget the G. And I know we'll get into some more of common law standards and how to calculate whether we should be doing ESG and things like that. But just want to be very clear that it's more than just environmental issues, even with the pensions we're talking about here today.
All right. So as far as then other states go, I mean, how transferable is this to other states? And John, we could get to you in a minute, but I just wanted to explore that, Vinny, since you have done so much around the country. We have, I know from my own work that that states vary. Some adhere to the ERISA standard pretty closely. Others have a much more squishy, almost like a business judgment type of approach. So New York kind of stands out with the more common law ERISA type of thing. So what's your view over the ramifications of this nationwide?
I mean, I think for those that are following common law standard and having that based not on standing, but on the fiduciary duty, the prudent man standard, as if you follow the Employment, Retirement, and Security Act, ERISA, 404 requires solely in the interest of the participants and the beneficiaries, and it goes through saying, well, it should be for minimizing expenses and maximizing return and minimizing risk. It'll have probably a pretty substantial aspects there. Also on some of the private sector funds, if they're now looking at, okay, it's a good brushback pitch. I know John is going to probably get into some of the other areas where maybe it's not as clear, and happy to defer to you. I know you've done a lot of good work on that.
So, all right. So then let's get into maybe some of the issues of the lawsuit itself, and especially the pushback from the city.
Mm-hmm.
So, John, I wanted to talk to you. Let's start with standing.
Yeah.
Because basically, they're challenging that they're really. I guess the central message is that there's no real right for them to sue because there's no injury, and in fact that look, the pension fund is 80%, or there's a variation from one to the next, but 80% ish. Fully funded, and that's better than a lot of them out there. And so, look, this will be around. And then there's a constitutional provision in New York that requires these things to be covered in case they go bust and can't cover their obligations. So, what's the controversy here? Why should they sue?
Yes. And let me start, as ceremonies of this type should start, with a public confession of sin, that being my own envy, that we, Gibson Dunn and not Boyd and Gray brought this lawsuit, because it's an awesome lawsuit. Like, I saw the news drop, like, oh man, been thinking about this, and they actually went ahead and did it. So kudos there.
I'm sure there's a lot more out there down the road.
Yes,
plenty
absolutely.
of work. Plenty of work.
Cake
hopefully.
for everyone in
That's
this cake
great.
eating contest. So yeah, I think on standing, the state is making a pretty aggressive move by trying to impute concepts that apply in the ERISA context, where the Supreme Court of the United States itself made a pretty clear distinction between how things work under state common law versus this federal statute. Whereas in state common law of trusts, I think it's either uniformly or very close to uniformly the case that a breach of fiduciary duty is alleging that is sufficient to state an actionable claim that's going to lie under the jurisdiction of the state courts. There's not a need for a separate showing of harm. That is somewhat different from how things are at least typically understood under federal Article 3, and so I think that's a really important distinction here. And here we've got that. We've got all of these statements by trustees, by fiduciaries that they are pursuing. This is one of the kind of the sloppier sort of ESG type cases in that regard, where there's less work being done on the front end to paper up collateral policy concerns in the language of financial materiality. To be sure, there is some of that they papered it up with. There's a BlackRock report, right, and another report as well. But there's a lot in there. If you just look at this in the complaint, saying, we're doing this because we've got to fight climate change, and the kind of the nexus with the city employees' benefit and interest is thin, to put it gently. So I think that, if this was a case being brought exclusively under federal law, I do think that it would be rougher sledding. But it's not, so it isn't.
So then when they talk about no cause of action then, and about, they dispute the breach of fiduciary duty because they say, look, we have a couple of draft analyses that we relied on, and notwithstanding public comments to the contrary, this was a very deliberative type of process. So how does that kind of stand? I'm thinking too, in the future for, perhaps private sector kind of implications, and especially to challenge fiduciaries on that aspect, whether the ramifications there.
Yeah, I think the rationale, the alleged pecuniary rationales that are being put forward are pretty thin, and this despite so to try to say like, no, we're looking out for you, we're looking out for maximizing returns. It just so happens that what we want to do lines up with all of these kind of conventional elite interests. Who to thunk it? There's this whole, I alluded to this, Paul, there's this whole cottage industry funded, I believe, in part by like kind of the change in Mike Bloomberg's couch, which like SASB, Sustainable Accounting Standards Board, and a whole cottage industry that is devoted to taking these collateral policy concerns. Most commonly, it's going to be about climate. It also happens with diversity, and trying to transmute those into dollars and cents, risk-adjusted return things. But if you kind of scratch the surface on these, prod them just a little bit, they start to fall apart. The climate-related financial risk as a rationale for this kinds of activity, a lot of it, and if you want to read about this in excruciating detail, we did 183 pages of comments to the SEC climate proposal on exactly this. So, if you need help sleeping at night, but the like physical weather risk is one component that gets bandied about. Transition risk is another component, and neither of them really match up in ways that you would expect if this was a conventional, true risk-return analysis. And the same is true with the literature, I hesitate to call it that, purporting to show like improved corporate performance with greater boardroom diversity on the basis of skin color. That's even the SEC had to back away from that in the NASDAQ context.
And if I could add one thing on that, the question of these analyses, the draft reports, we know what work they did. It's telling that there are two other large New York City pension funds, the Firefighters Fund and the Police Officers Fund, who are in the same room, in the room with the Teachers Fund and the other funds that are the defendants, heard the same purported presentations, received the same materials, and whatever analyses may not have been done, and then they declined to divest despite the mayor's push and the comptroller's push. And they made public statements, and I think it's a very telling public statements. The trustee from the police union or the police pension fund said, "We don't see the funds as an object to be used to make political statements. Our job is to provide for our retirees." And a trustee from the other fund said, our views on social and political issues can't enter the equation. The same is true for the elected officials who sit on the board. So it's very clear from there, number one, that this was being driven by a political agenda and not because they had received some incredible presentation about, behind closed doors about how this was really going to lead to maximizing returns. And number two, that as responsible fiduciaries, they declined this political push to divest, while the other three funds that we ended up suing buckled under the political pressure.
Well, and we'll get to questions here in a minute. I just wanted to go into the other issue that this Corporation Council raises, and that's justiciability of this case. So what's a poor judge to do? It's how does he second guess what's going on behind closed doors and all. So how do you parse through those sorts of claims or counterclaims here?
So I guess I would just briefly, I would say that, yeah, some of that stuff is hard. Like it is, especially when litigating a fiduciary's duty of care, there is a real risk of inviting the court to engage in Monday morning quarterbacking after the fact about how things have gone. I think it is, difficult to conclude from that I think it's very difficult to conclude from that breach of fiduciary suits are never appropriate. The fact that it's hard doesn't make it impossible, as I tell my children all the time.
Yeah, and one thing to kind of reinforce that is, especially in some of these states where there's not so much publicity as maybe on the federal level, you have an invitation for hanky-panky to go on with some of these funds, and if the fiduciaries are not held accountable by the beneficiaries or not able to do it, then you could have a situation like in New York a few years ago. One of the controllers, was basically, prosecuted for doing things with the money of the fund that he shouldn't have, and including investing in the allegations were investing in sort of crony type of projects that this is before I think ESG was a term.
Paul, he should have had SASB paper it up.
Yeah, bro. Yeah, right. But anyway, but you get the drift, where you can reward friends, through the allocation of state pensioners' funds into a kind of dicey or shady types of deals that in fact just redound to the fiduciary's benefit. So anyway, and there's a long strain of standards under federal law, ERISA law, that for the sole duty ideas that if you veer one iota off of having laser focus on what's best for the beneficiary, then you're out of bounds, because even if you can say in a memo, this is the next best thing since sliced bread to invest in, but at the same time will save the world, then arguably that's a divided loyalty there. So anyway, so one before we turn it over to the audience, I wanted to ask about some of the other states that were the especially conservative states, run by Republicans, are kind of taking an opposite tack about their efforts to strike back at what's going on with money managers, to either forbid them to participate in state funds, state investing, or other more draconian things. So I was wondering what you all have to say about those sorts of efforts.
If I may, I've got some views, which is, so oftentimes, so we've got a lot of red states, a lot of more conservative states are starting to push back against BlackRock, other asset managers, through a variety of mechanisms, sometimes having to do with their state procurement and contracting, sometimes having to do with their investment criteria for state public pensions. And my sort of cards on the table, broadly speaking, I think these are very positive developments. But for this conversation specifically, I want to point out that I think in order to most fully and properly justify these kinds of moves by redder states, I think it is helpful to look back to what I would really call the original public meaning of public pension fiduciary duties here. And what I mean by that specifically is that the conception, like these pensions are always supposed to be, they're trusts, they're supposed to be administered for the exclusive benefit of the trust's participants and beneficiaries, that kind of thing. And historically, with public pensions, the connection between those beneficiaries, their particular interests, which are larger than their interest in the plan assets, that there's a larger penumbra of interests that those beneficiaries distinctly hold, that there's a longstanding connection between public pension administration for the benefit of those interests and pension management. Gentlemen, I'm going to fulfill your daily requirement to think about the Roman Empire and look at the earliest example that tends to get trotted out is the pension system of the Roman military, where a lot of those pensions would be for retired and disabled soldiers would be funded through the spoils of war, through like this, here's a gold goblet, here's a governorship of Illyria, whatever it might be. And those are the plan assets. Those are the spoils of war are the plan assets in that context. But the fiscal sustainability of the pension was always determined, at least in part, by the conduct of the enterprise. Like, how was the military doing in conquering Gaul or Illyria or Galatia, Iberia, whatever it might have been at the time? The pension's funding was not separate from the sort of the business, if you will. This is a theme that goes through every early public pension history we're familiar with. To bring it to go with the founders and translate from the Roman context to the early American context, the U.S. Navy's initial pension system was funded in large part this way. It was funded by captures, by prizes, by spoils of war, and again, the proceeds from the prosecution of wars. My office is across the street from the Decatur House. Stephen Decatur, of course, I believe, had some big wins against the Barbary pirates along these lines. That pension system was bound up in the prosecution of America's wars. I don't know exactly how it is. There's a lot to be said about how we've gotten to a more strictly financial value of plan assets conception of these things, but of the public pension fiduciary duty. But I want to point out in the modern context, state pension funds often look at prioritize in-state investment, which can be, I would argue, can be done for the exclusive benefit of plan beneficiaries. And then the last thing I want to associate myself with is this may be a little bit unfair, but then Secretary Gene Scalia invoked precisely these kinds of benefit considerations in his instructions to the Thrift Savings Plan, the gigantic federal public pension system, when instructing them to divest from Chinese military companies. Secretary Scalia invoked both a pecuniary risk-return rationale and a national security rationale, acknowledging these are somewhat separate, they don't collapse into each other, recognizing that the interests of these plan participants, in that case, the uniformed service members who were TSP participants, their interests were affected not only by risk-return, but by the prospect their investments would be used to finance munitions that could lead to weapons of war against exactly them. So I am proud to associate myself with Eugene Scalia.
Okay, all right.
I would love to associate myself with Eugene Scalia as well. I will agree with you on that. I will disagree with you on some of the other factors. Now, first to the war analogy. I mean, as much as there is a rivalry between Michigan and Ohio, I don't think Michigan is going to invade Ohio to help supplant their pension fund.
Not thinking big enough for me.
We'll get there. The second is there's a second clause I think you're leaving out, and it's not just for the benefit of plan participants and beneficiaries, but when you look at ERISA, when you look at some of the common law standards, it's to provide for their retirement. Aside from Michigan conquering Ohio, which I think they would do and have done. UP was a much better deal than Toledo. Another story. But it's also to defray expenses, and I think that is one of the things that also gets lost in the ESG context is, you're not just talking about, okay, well, we want to divest from fossil fuels, let's just do it. I thought the Trump rule was fantastic. I wrote a comment in support. Big fan. Except that there was a part of the Trump rule that I have a little bit of disagreement with, and that's the all things being equal test. If you have two investments, and granted this is a unicorn, if you have two magic investments that magically have the same risk, the same return, then okay, you can put your thumb on the scale. The problem is you have to research to put your thumb on the scale. You go back to Akiva, your case, and I thought you were really good about saying that there was a 3-year pressure campaign. Well, for the fiduciaries of those pension plans, how much mental energy, how much time, how much money did they have to go through to say, yes, we're going to divest from fossil fuels, or even researching, okay, this is a good political investment. So when you come down to it, whether it's the left, whether it's the right, if you start putting your thumb on the scale, you're then using resources that should be going to investigating further future investments towards putting your thumb on the scale to advance your own political agenda. So rather than a all things being equal standard, I think those investments should be caput et navia, and whichever way you want to go, there should not be any extra effort or expenses paid, and that's one of the chief problems with ESG. Going back to Latin.
Yeah, what is that? What is caput et? What did you just say?
I just said caput et navia, and if you'll permit me to bore you. So when I was working on the two interpretable bulletins into the Bush administration, fresh out of law school, brand new appointee, was researching this. Eventually, I thought the memo would have the secretary would have eyes on it, so I wanted to make it sound good. Same problem with the all things being equal standard. You can't put your thumb on the scale. So I wanted to say flip a coin, but of course wanted to make that sound a little nicer. So if you know Roman coins, there's a head on one side, a ship on the other. So if you are selecting between totally equal investments, it should be caput et navia. It gets better for you labor lawyers out there. If you're familiar, many Roman coins, that head was the god Janus. So it has several layers of benefit there.
I'm totally working that in next. If I can, one additional observation. So agreed as to one of the things that the new rule, and we're in court arguing that the labor can't do this. The new ERISA ESG rule the Biden administration has promulgated takes this tiebreaker concept, and instead of narrowing it to caput et navia, they've said there's a lot of circumstances functionally in which there could be a tie, and that's I would argue grossly in conflict with the text of ERISA. But I do want to caution against readily conflating ERISA and the common law, because sometimes they're the same, but at other places there's really meaningful distinctions.
Yeah. And by the way, just as a baseline, ERISA, you think private sector pension plans, DB plans, common law or individual states, that's public sector. Federal, private, state, public.
So anyway, so this has been great. We have a great history lesson. So never say that at a Federalist Society event you don't get history, and especially Roman history. So I want to let you all, seeing the time fly here, I want to give an opportunity for you all for questions. Yes.
So this is part a question, and depending on the answer, perhaps a suggestion. So this business about standing, about defined benefit versus defined contribution plans, and what the rule is under ERISA. So the logic of that is, in a defined contribution plan, your benefit is the account balance. So anything that affects the performance of the account, right, is going to give somebody standing, right? If, on the other hand, with a defined benefit plan, generally the promise is completely unrelated to the funding. If you're saying we're going to pay you $500 a month starting at 65 for the rest of your life, right? And so the logic of that is plaintiffs don't have standing to sue a defined benefit plan for fiduciary issues or mismanagement of plan assets, because the promise is a fixed amount unrelated to the funding and is backed by a federal guarantee corporation to go with it in case the employer becomes insolvent. That rule has never been tested against a particular type of defined benefit plan, and those are what's called contributory defined benefit plans. So there, in the private sector, there are virtually no contributory defined benefit plans left, and those are plans where the employees actually, their pay is reduced as a condition of participating in the plan. Virtually all public employee defined benefit plans are contributory. I quickly checked. I haven't looked into the New York plans, but I just quickly checked the NYCERS, and it is contributory. So it is not unusual to find in a contributory defined benefit plan, if you dig into the plan, a minimum benefit which is based on the employee contributions and the funded status of the plan. There also may be language that if the plan were ever terminated in a surplus position, some of the surplus would belong to the employees who made contributions. So I don't know whether you guys have looked into it, and maybe you did and you found there's really nothing there, but I mean, that might be worth exploring.
I will say it's not something that at least not something that reached me as far as that distinction. That's not to say that that somebody didn't look at it, but I think it's interesting, and I think we should we'll look at it. But I think fundamentally the standing issue from our perspective is just straightforward. You've got an alleged breach of the duty of loyalty, and that creates standing under New York common law. And so we do, as a fallback, note that we allege that these plans are under 80% funded in some cases, and that is the sort of threshold for a plan in distress, and that New York City has financial problems, and that it's not inconceivable that there could be a bankruptcy if the plan, and I think our allegations there are good enough, even under Thole. But since we're starting and fundamentally and primarily with the common law standing point, I think probably the finer distinctions there that you're laying out don't really matter from a standing perspective, or at least we don't need to go there. But it's interesting and probably worth digging into. And I guess the other thing I would just say on standing is, and this is I think just a helpful practice pointer if anyone else is thinking about bringing follow-on litigation in some other state, why not, is that New York also has a fairly liberal doctrine with respect to challenges to government action. So there's a sense that somebody has to be able to sue under New York law. There's got to be somebody out there that has standing. And so that's not 100% rule, but there's a thumb on the scale on the side of standing. If you've got to challenge the government action and you've got the people there that are as well situated as anyone else. And so, that's certainly our situation. So, again, I would think you got to really think state by state and maybe think about what states you want to go in from a standing perspective, because there's a broad array of standing principles in different states. But in New York, at least, there's a real thumb there, and if anyone's going to have standing, it should be our plaintiff. So we think we shouldn't have an issue there.
Yes, ma'am.
Social science and deficient financial analysis that backs up everything the left does. And I'm not sure what's in the BlackRock report, but some of these things are along the lines of, after a tremendous campaign to vilify an industry, then they'll say, and you can't invest in it because it has reputational risk. And I can only say that perhaps the only good thing that's come out of the Ukraine war is it has demonstrated the real need for fossil fuels and the value of those investments, which cannot be erased, hence setting up your lawsuit. So here's my question, is about damages, and I'm not a litigator, so I'm not quite sure how this works. Do you just ask for an injunction, don't do this anymore? Do you actually try to make somebody repay the losses, which I'd assume would be enormous. If you ask them to repay the losses, is that too scary for a judge that he's going to further push New York State into bankruptcy? Just a comment on that, please.
Yeah, I mean, I guess I'll just briefly comment on that. I don't know if John or Vinny have any comments on that general topic, because I don't want to dominate the Q&A. But I mean, primarily what we're asking for is a declaration that they violated the fiduciary duties by investing in based on the political priorities, rather than for the benefit of the fiduciary benefit or the pecuniary benefit of the fiduciary of the beneficiaries, and then a injunction going forward to invest in accordance with their fiduciary duties in a forward-looking way. So I mean, that's a broad or general concept, and then maybe that plays into the justiciability concerns that they raise. I would say to that doesn't mean the case can't get into court on the front end. The court's got to adjudicate it, and then there can be a conversation about how you monitor it on the back end, after we win. And then, I mean, we have put in a request for a compensatory, damages request. I think that is not, primarily our goal, though. I don't think I'm revealing any secret to the city to say that. What we really want is that declaration, that injunction.
Yeah. Go ahead, Vinny.
Oh, go for it.
I would just add the collateral value of such a declaration would be really profound in everything else that could be done to bring this sort of practice to heel in all these other public pension systems that are running amok.
Yeah, I think you both summed it up pretty well on the damages. I do want to go back to one more thing that you were saying in the introduction of the reputational of, they try to have these campaigns against these companies and say, oh, reputational damage, and go, that's actually the heart of what a lot of these union-friendly proposals are all about. It's reveal your collective bargaining policies, and then we're going to go after you because you're not friendly to workers. Or reveal your DEI policies. Oh, you don't have DEI policies, so we're going to go after you and paint you as here's the parade of horribles here. So it's not just these shareholder activism proposals that are actually working to future down the line work against the company. So there's pretty part and parcel that's a breach of fiduciary duty right there. And that really is the heart of these union proposals, of being able to air dirty laundry or try to make it look like dirty laundry for some of these companies, so they can strong armor them into taking away things like the secret ballot from workers.
Mark Wheat, you had, and then up here. So,
thanks. The left is not active just on environmental and fossil fuel issues. They're active on a whole range of issues. And so my question, which is back in the news again, is, are there public pensions that have still gone along with the BDS, the anti-Israel BDS movement? And I'm sure that they're not going to be trumpeting their positions on that after this weekend. But are there public pensions that still have their investments controlled by a BDS position?
I don't know the answer to that, and I'll defer to the others if they do. But I do want to say on BDS, and I have 2 daughters in Israel now, and actually on my way here was thinking about, do I want to say something about the situation there? And to be honest, my head is not even fully here because of that. But I've also, more to the topic of what you asked, litigated in defense of the state anti-BDS laws, because the challenges to their constitutionality, for those who don't know, 20 some odd states have passed laws saying either that the state investment funds can't invest in companies that support boycott, divestment, of sanctions of Israel, and or they will not allow contracts to be entered into with contractors who either companies or individuals support BDS and are actively engaged in boycott. The reason is that those are discriminatory activities, boycott against Israel and Israeli companies, and so it's an anti-discrimination measure. There have been First Amendment challenges. Thankfully, we have, every appellate court that has faced the issue has found that those are constitutional and appropriate laws that states can use their funds and their contracting powers to advance their priorities. If their priority is anti-discrimination against Israel, that's a legitimate priority. So I don't know the answer to that question, but I do want to say that to the extent that there are states that are considering, there's been a big push, and I think it would be a great thing if more states would decide not to support BDS movements and enshrine that in their state laws.
Oh,
Go
sorry.
ahead. No,
Go
go ahead.
Should I use the mic? Hi, Kurt Levy, Committee for Justice. To what extent, I address this to all of you, to what extent, if any, do you see a connection between these ESG lawsuits and the climate litigation that's going on, in which New York City and a bunch of other cities and states have sued energy companies for what they say is the billions of dollars in costs it'll take them to mitigate the effects of climate change? I guess at very least, there's a similarity in that they make economic arguments, but it's really about a political agenda. And also, I was wondering, just with that last anti-BDS comment, to what extent how do you differentiate your lawsuit from the fact that pension funds are taking into account policy on Israel?
Yeah, that's a great question. I don't know if I answer that first and then go
Why
to
don't
the
you go
other
for a minute,
question.
yep.
So on that, I think the important distinction is that those anti-BDS laws are the states using their own money for their political priorities, and I think that is, there's a long-standing and well-established case law that states can use the contracting power, for example, in favor of something that they think is a political priority. And if you don't like what the governor's doing with the state's money, you can vote in a new governor, whether that's an anti-discrimination law or it's abortion law or anything else. So that, and those laws are very cognizant of the constitutional issues and therefore targeted at those two things: state investing, meaning investing of state monies, or contracting with the state, meaning using state monies for contracts. The distinction, and I'm glad you asked the question, because it does initially look like maybe there's some tension there. The distinction here is that these pension funds are investing their beneficiaries' money. This is not state money. And that's the whole problem here, is that they think of this money as public money that they can do with it as they want because they're public officials, but they're not. They're trustees. In this capacity, they're trustees of beneficiaries, and they have an obligation under the common law, under New York regulations, and the New York regulations do have very ERISA-like language that they have to be, that their actions have to be solely for the benefit of the beneficiaries. And so, that's the distinction there in my mind.
If I can add to that, that keep in mind that the relevant trust law is going to require the administration of a pension system for the exclusive benefit of the participants, of the beneficiaries. That of itself does not. If I could sort of leave the body with one thing, I think what unites more or less, I would hope, everyone here is a conviction that what NYCERS is doing, the kinds of conduct alleged, if true, is deplorable, is a misuse of public trust, is a breach of those public responsibilities. The question, though, is how to respond. Do we come at it with a sledgehammer, or do we come at it with a scalpel? And I'm pretty firmly of the view that the more surgical approach is the right one. Otherwise, for example, if you reduce in every occasion the public duty down to one of maximizing plan assets with no other concern, which, as I've argued, is not fully consistent with the exclusive benefit rule, you end up in a position where public pensions may be invested in the outsourcing of a state's economy, for example. That's a real problem. Or, as Secretary Scalia rightly warned about, supporting a geopolitical rival to the detriment, again, of the benefit of the beneficiaries. So I think that more surgical approach is the way to go.
I agree. It should be surgical. I think it's up to the elected leaders, and having states pass anti-BDS laws, especially in light of everything that's happening now. That's where it should lie, and that is above the fiduciary duty. But that's not up to the fiduciaries. That's up to the elected leaders. And when you're talking about national security, when you're talking about, let's get away from some of the geopolitical stuff. Let's just talk about TikTok. Still with China, if it's a security risk, and you have a state saying, well, if you are a union, if you are a pension fund, or even if you're a state employee, you can't have TikTok because that opens security issues. That's where it lies. It lies with the elected leaders. I think we all need to, when we're talking about these issues, I think we all have to go back to that. I'll just call it the Harry Reid rule. Be careful what you wish for when you're in power, because it can come back to bite you, and in unexpected ways. So there's a lot of geopolitical things that I think, making sure that their elected leaders are supporting things and making sure that we're not going down these roads, that's important. But that's up to the elected leaders. That's not up to pension fiduciaries that have to stay within the law. And if the law says you can't do that, you can't do that. But their job is to maximize benefits, minimize risk, and defray cost for retirement.
Any quick comments on the climate litigation?
So the connection that I would make, sorry, I get down from my soapbox more generally and talk specifically to that.
It's a good view.
Yeah, it is. It's a great view. Is that the support for both all sorts of pension and investment fiduciaries, investment managers to favor ESG criteria, and the support for these climate litigation is often coming out of the same place. This is not the occasion to put the bulletin board up with this, yarn strings connecting photographs together, but like Charlie Day. But it is very much the case that these things are connected in terms of funding, and they're often relying on some of the same literature that is of dubious provenance, but only has credibility and traction because of so much elite validation. This stuff just circles around the same elite echo chamber. And if I can end with this, imagine what'll happen if this stuff comes back to bite you, Vinny. What if when you get the chance you can bite harder? That's what I want to know. Sometimes the shoe is, even if the shoe ends up on the other foot, when it is on the other foot, oh, this is really terrible. I don't know what precedent is being set, but that's a longer conversation.
Well, I think we're at time here, so or overstayed our welcome even. But anyway, obviously we could go on for a long more time. This is really fascinating. We didn't even get to other two topics like the ability of state AGs, not in New York necessarily in this case, but to vindicate rights of beneficiaries so in other states, and then especially we didn't even talk about private funds and fiduciaries and their responsibilities. So obviously that's for a topic for another day. But anyway, turn it over to you, Steve. Thanks.
Well, please join me in thanking this excellent panel. And thank all of you for being here today. And for more content like this, check out regproject.org. That's regproject.org. Thank you. Bye-bye.